News 4, Balance News you can count on.
In today's legal affairs segment, estate planning for unmarried couples, whether they be same-sex or opposite sex. This is even more critical because these couples don't have any rights or benefits automatically given to a spouse. Our legal affairs contributor, Craig Wisnam, joins us now, and we're going to start with tax, inheritance, and employment benefits, because really, they don't really have any, do they?
Well, no, it depends on the type of tax. The estate tax has a benefit for married couples in terms of an unlimited marital deduction, but that's only applicable if people have a pretty large estate, more than $3.5 million. So below that amount, there's really no difference.
Okay.
And for income tax, it may actually be a benefit the way things work out. But the important thing to note is that for a lot of purposes, the law guesses if you don't have your documents in place, whether it's will or power of attorney if you become unable to act. The law basically guesses who you want to have either receive your property or take care of your assets, and that they normally guess it's going to be your spouse if you're married or your children if you're not. And if you're in a relationship with someone whom you're not legally married to, none of those presumptions apply. And so that person, that other partner, significant other, whatever you refer to them as, has no legal rights if something happens and you die and become incapacitated. And so the message was pretty simple. Luckily, you can take care of all of that by putting into place documents saying who you want to get things, who you want to take care of things, who you want to make decisions on your behalf. But you've got to have them in place. It's even more crucial than it is if you're married.
And tell us about those documents.
Well, a power of attorney, a general or financial power of attorney normally names who you want to make financial decisions if you become unable to act. That means paying your bills, taking care of things like that, paying your taxes. A medical power of attorney names the person who's going to be making the medical and care decisions if you can't. And then a will, of course, decides who gets your property and who would administer your estate. So if you're in a relationship, you want to, assuming you want that person to have any of those roles, whether one or all, you need to put them into those documents.
Yeah, it's kind of, it would be rather sad not to have somebody in your life, but they're not your legal, they're not on any of your legal documentation, and they get totally shut out.
Absolutely. It can be just tragic when you see that happen. The good news is, while you're alive, you can basically fix that all by rewriting these documents that says who you want to make those decisions, who you want to receive your property, whom you want to take care of. So it's very easy actually to take care of and fix that if you're not married, but you got to get it done.
Yeah, because otherwise the government will make that decision.
Otherwise the government guesses who you want to get things.
All right. Craig, thank you so much.
Thanks, Martha.
More coming.